Hello. Shall we start our panel? I'm Joana Varon from the Center of Technology and Society at Law School of Getúlio Vargas Foundation, Rio de Janeiro, Brazil. Our workshop is entitled Freedom of Expression on the Net, Current Threats to the Internet's Architecture that Undermine Citizens' Rights and the Free Flow of Information. It's being organized in partnership with EFF as well, with Kurt Opsahl. The table, just to introduce the table, Elvana Taki from the Council of Europe, Desiree Milojevic from Affiliates, Pedro Les, Senior Policy Counsel at Google Latin America, and Kurt Opsahl, Senior Staff Attorney at EFF. Let's just start with a brief introduction of their respective organizations, and then we go to a brief presentation, and then to a set of questions. Kurt?
Thank you. Yes, I'm Kurt Opsahl. I am a staff attorney with the Electronic Frontier Foundation, which is a nonprofit civil society organization dedicated to protecting privacy, innovation, and free expression in a digital world. We've been around since 1990, over 21 years. We have over 15,000 dues-paying members in 69 countries, and they all have a strong interest in helping policymakers develop a future we would want to live in.
Well, my name is Pedro. I'm the Policy Counsel for Latin America for Google, and also coordinated our team at the Internet Governance Forum. We are internet company, search engine, and mainly also other services. We are very, very concerned about the different implication of protection of freedom of expression on the net.
Okay, I'm Desiree Milojevic. I'm a senior public policy advisor at Affiliates and associate researcher at the Oxford Internet Institute. Affiliates is a 10-year-old company that was born out of the ICANN process to manage .info top-level domain name, and today we power about 15 top-level domain names, including countries that are developed and in developing countries.
Thank you. My name is Elvana Taki. I work for the Council of Europe Secretariat in the Media, Information Society and Data Protection Division. I would like to say a few words about the Council of Europe in my presentation. For the moment, I'll just say that the organization seeks to promote values such as democracy, human rights, and rule of law. Thank you.
So just an introduction about CTS. We are a research center focused on IP law and internet regulations, focusing on balancing IP protection and public interest, access to knowledge, and bringing those issues to the internet, and discussing that. We are very close to Brazilian policy making. We work like a think tank in those issues. So if Elvana could start.
Thank you. So again, I'd like to say a few words about the organization. The Council of Europe has 47 member states, 47 European member states, representing 800 million people. The organization was founded in 1949, and since then it has engaged in activities to promote its core values. The activities are primarily standard-setting activities, development of policies and standards in the areas of human rights, democracy, and rule of law, monitoring of the implementation of standards on these areas, and cooperation with member states in different projects. I would also like to mention the jewel in the crown of the Council of Europe, which is the European Court of Human Rights. All European citizens can go to the court, file complaints against their states for failure to protect fundamental rights and freedoms. And we're proud of this institution. I understand that you'd like to, the organizers would like me to say a few words about the activities that we do in the area of freedom of expression, particularly. So I won't waste much of time, but I'll go directly into that. I'll mention some of the standards that we have developed throughout the years on the protection of freedom of expression and freedom of the media. As they relate to the internet in particular. For example, there was a declaration
are indemnified from their role, that is to be intermediary, and we can see that in various legislations, including European ones, they can suffer from very serious financial and legal damages. To quote maybe just one example is the court case that is still not finalized and that might be interesting for discussion later on, is the Sabam and Scarlett law case, where a Belgium collecting society has actually filed a court case against Scarlett with regards to copyright infringements, and has asked the intermediary to filter all the traffic, and has also tried to cut down all the P2P network. With regards to the court ruling of the Belgian court, we have found out that the technical expertise have proven that there are quite a few things that one should be able to question here, and primarily whether the disproportionality of the order to filter all the P2P traffic, and whether that's possible, and also to question the complete effectiveness of actually being involved in such an activity. So as we know that the European Court of Justice is yet to have a final say on these two findings and on the preliminary ruling, and it may take up to 2 years to find these questions, but I think nevertheless it's an interesting example from to actually share here, and to see that Tiscali or Scarlett ISP could be liable for a lot of damages. And taking that further, we can also think what kind of consequences that would have for intermediaries that are set up in developing countries, where they could be legally and financially responsible for the traffic that they carry over the internet infrastructure, and dealing with the unknown financial responsibility and legal liability is not a good position to be in, and to carry out business. One other notion that I would like to introduce before I stop is this, the notion of intermediary and the difference between being an intermediary and being a publisher. The minute you start actually regulating the intermediary, you're turning them into a publisher. So, for example, we have an example that root server operators do not edit the IANA zone root file. They're merely distributing the content of the IANA root zone file, therefore they're not publishers. And similarly, intermediaries should be publishers, should not be publishers of information, they should be intermediaries, and I think it would be good to have a little bit of more discussion there. In Europe we have the e-commerce directive, the 2000, and we have the mere conduit principle, Article 19, which actually describes the position of ISPs, where they're there to conduit information. However, the ISPs are currently not free from financial liability, as well as they're not free from legal liability. And we have other issues, I think, that would be useful later on to touch upon in discussion about the clarification of personal data definition under the data directive. I've just touched based on the copyright laws and some of the major influences in terms of trying to regulate some part of the internet infrastructure, but I think we'll hear more about that from other panelists, so I'll stop here now.
Thank you, Desiree. Pedro?
Well, I think that it's very important to be in this forum, and also for the different stakeholders of the internet and human rights community to step up jointly in defense of freedom of expression online. As an internet company, I would like to share with you some experience on what happened to us in different countries, and how we have been fighting to basically support the freedom of expression online. Currently, many governments around the world are attempting to exert more control over the net. More or less, more than 40 governments are in some way interfering with internet services or content. And it ranges there are different behaviors here that from strictly, they are blocking strictly political content, or there are measures that are addressed to really vaguely cultural content that could be, it's really difficult to determine the harmful content on that online content. In terms of Google and YouTube services, we have been subject to censorship in at least 25 countries around the world. If you would like to learn more about this, we have a transparency report that you can get all the information about the different requests from governments that we receive, and also the blocking of our services in almost real time, because you can check in the different countries how is the level of traffic of our service in the different products. So you can be able to identify if it's if a drop of our traffic happens in the different products. This could be onto a technical failure, sometimes could be related to a political or government decisions around it. I will give you a very recent example that happened in Argentina about a month ago, when all the internet service providers in Argentina received a notice from the National Commission of Communication, that is the telecommunication regulator, to comply with a court order that orders the blocking of 3 websites. What happened is that many ISPs proceed with an IP blocking, because in one of the court orders, an IP has been stated in brackets next to one of the domains. The consequence of that was that more than 1 million blogs hosted in Blogger has been blocked, just because the ISPs block the IP address rather than the domain name. This case has to do with, the order has response to a request from the government related to a website called Leaky Mails that expose military and political secrets. Fortunately, we have been able to work around this issue with different stakeholders, internet chambers, and also we address this issue with the communication authority. And the judge issue a new order clarifying that the measure should be done in a way that does not affect content, which is or website, which is not the object of such court order. We're not discussing here if the court order was granted or not in the specific case, but the question of how sometimes it's very important for the different legal operators to be very specific on the way that they present a court order, for example, because sometimes the ISPs are caught in the middle and say, well, I have a court order that says I have to block this IP address, and it's very difficult to measure the consequences of that. In that case, was almost for 3 weeks that 1 million blocks was not available in Argentina for the major ISPs. In terms of, I would like to make a recount of really very important things that happen in the human rights arena in this past year. I would like to start with some remarks from the Human Rights Committee of the United Nations, who recently emphasized that the protections warranted by the International Covenant on Civil and Political Rights applies fully in the online world. For example, bloggers should receive the same protections as journalists. Another highlight of this year has been the report of the Special Rapporteur on Free Expression of United Nations. I think that maybe Frank is around here, Frank LaRue. And in his report to the UN General Assembly, he emphasized that restricting the flow of online information also violates human rights. The report, for example, opposed to initiatives like the 3 strikes internet laws that we have been seeing in different countries like France, for example. And these 3 strikes laws are designed by the government to discourage internet fair shares and allowing authorities to get internet users unplugged permanently from the internet. I think we really look forward for the approval of the report prepared by Frank LaRue, and encourage you to address this with your countries to get support on this initiative. I think that this will be very, very important for the protection of freedom of expression on the internet. Finally, this is really a very, very important document. It's a joint declaration on freedom of expression on the internet. This happened a couple of months ago, and it's a joint document signed by the UN, the Organization for Security and Cooperation in Europe, the Organization of American States, and the African Commission on Human and People's Rights. This declaration has been signed by each of the free expression rapporteur of those organizations. In my view, this is one of the most important and comprehensive documents that has been written so far on this subject. It will be very important to encourage its adoption, the adoption of the principles set forth in this declaration at national and regional level. Just to give you an overview of what is in this declaration, it sets out several important principles that includes freedom of expression applies. Let me read you some. Freedom of expression applies to the internet as it does to all means of communications. Any restrictions are acceptable only in the various occasions when prescribed by law and if it's in compliance with international standards. Internet service providers that provide the platform for free expression cannot be held liable for illegal or harmful content generated by third parties. This is in line with what Desiree was saying. Mandatory blocking of websites or IP addresses represent an extreme measure, analogous to the prohibition of a newspaper, radio, or television station. The single publication rule should be respected. It holds that damage can be recovered only once for any single piece of content. So these are really, really good developments that we have this year in terms of freedom of expressions and the internet. But also, I would like to drag your attention to very, very new documents that come up. And I think that this will be a very interesting forum to analyze it too, and has to do with an international code of conduct for information and security. That this has been submitted by permanent representative of China, Russia, Tajikistan, and Uzbekistan to the UN Secretary General Ban Ki-moon, asking him to distribute this international code of conduct as a formal document on the 66th session of the General Assembly, and is calling upon countries to further the discussion of this document within the framework of the UN. I think that it is important to analyze this proposal. I have seen very, very alarming wording in this proposal, and I think that we need to analyze this in light of the principles set forth in this joint declaration of freedom of expression, on Frank LaRue report, and also on the International Covenant on Civil and Political Rights. So I leave this open for further discussion during this session.
Thank you, Pedro. Now I'll change my hat from moderator to speaker and bring some inputs to the discussion. I'm going to talk a little bit about research we are doing about filtering practices in Latin America and how it impacts freedom of expression. So it relates a lot with what Pedro was talking. The goal of the research was to analyze legal provisions that open space for filtering practices in the region, assessing how they, or if and how they can treat freedom of expression, For that, we look at net neutrality provisions, either laws or draft bills, content regulations, and regulations about ISP liabilities. And the countries where we focused the research were Brazil, Mexico, Colombia, Venezuela, Chile, and Argentina. This research is being made with a joint initiative or proposed by the Centro de Estudios en Libertad de Expresión y Acceso a la Información of Palermo University, Buenos Aires. So what we saw and what was our hypothesis was that even though Latin America is not being presented as a region full of the so-called internet enemies in terms of internet freedom, if we look to researches about freedom of press, like the Reporters Without Borders reports, we can see the region have substantial problems on the offline environment. So the hypothesis is that if we pass to concerning digital inclusion and improving access, we can pass to problematic situation to the online environment as well. As we could see, for instance, Venezuela has just approved a proposal on internet content regulation that restricts information that could be seen as media manipulation to alter public order. And also, this regulation sets that these regulations blocks contents that restricts the access of messages that are contrary to national security, and also predicts the creation of an app for traffic management and ISP liability for the content that is being posted on their platforms. So it's a very threatening provision. The same happens to Mexico with a proposal to monitor social networks. In Colombia, in Mexico, the excuse is to monitor drug dealing. In Colombia, there is a project on content regulation allowing ISPs to block access to content after notice mechanism without judicial order. So it's a Hadopia-like provision that was being discussed, and it won't pass, but it was in the topics. In Brazil, we are moving towards a better situation once the civil rights-based framework just reached Congress. But until now, as we don't have the law approved, the environment is uncertain, so it's quite common that we face blockings. We are in the top of the list of content removal from Google Transparency Report that Pedro just mentioned. So let's see how it goes after the approval of the law. For the research, we took into account the requirements that was highlighted and presented at the report of Frank LaRue, the special rapporteur on freedom of expression, which says that if filtering must happen in extreme cases, just as child pornography, we must take into account that it must be provided by the law, with clear and accessible, which is clear and accessible to everyone. It must pursue one of the purposes set out in the Article 19, paragraph 3 of the International Convention on Civil Political Rights. So it says that it's only in case to protect rights and reputations of others, protect national security or public order, health and morals, and the second requirement is that it must be proven as necessary and proportional. The second requirement that I just mentioned under Article 19 it still opens room for a lot of provisions, and it might be threatening. So what we are trying to assess was looking at those content regulations in the countries, if they are using in a extensive manner. And just to conclude, so we saw that even though only child pornography in those countries has a specific regulation for the online environment, other content regulations are being used for filtering and excessive filtering and blocking. Mostly in Mexico, Venezuela, and Colombia, under defamation and copyright provisions. Brazil is also the case, mostly in copyright, and defamation was the case during the elections. That's interesting because, of course, during the elections, with the debates, I think it's part of the political process to comment and bring inputs, and a lot of those comments were like considered defamation, and then content has been blocked. This was the case of a report of a page that was talking about corruption against Senator Sarney, and it was blocked, and it's a clear case of infringement of freedom of expression in which defamation law was used to take the content off. So on the other hand, those countries that we analyze are talking about net neutrality laws. I know net neutrality laws are not specifically focused on, of course, in internet freedom or freedom of expression, but it's a technical law, but it has some lines on it, and it can be used to balance improper removal of content. So those countries are debating this by now. What we saw also was that within all the intermediaries, internet service providers has been targets for the actions, and mainly those who deal with social networks and research mechanisms. Brazil and Argentina were the main examples of that. And finally, after those legal actions, what we saw is that the judicial orders are not specific about how the filtering, if it must happen, how it should happen. They don't talk about transparency, so you will enter a website that has been filtered, and you won't know about it. And so those are the inputs. And just to finish about this problem on judicial orders, so the orders for removal of content do not set those standards for filtering. What happens is like a vicious cycle. They do not set standards, so intermediaries are due to set those standards. We take them, by that, private decisions have to be made under a public interest issue, which is access to knowledge, access to content. And also the private sector, or the intermediary, is still deciding without a proper clarity of the judicial order. It still is suffering the risk to be questioned again if he's implementing a mechanism that's not enough to solve the damage. So there is an environment of legal uncertainty for both intermediaries and users. This environment becomes an incentive for the adoption of more filtering mechanisms without transparency and acknowledgement of users. And on the other hand, we don't see in the law incentives for protecting freedom of expression and protecting users and the right to access this content. So in order to be safe, intermediaries might tend to filter more. So that comes to the debate on try to implement principles that protect users' rights on proper legal provisions. So that's why, coming back to the debate on principles, it's very important for us. I'll wrap up here and pass the word to Kurt.
Thank you. So Kurt Opsahl with the Electronic Frontier Foundation. I started by talking about what kind of future do we want to live in? I think that is very much sort of the question that is trying to be answered when thinking about internet governance and thinking about how we should structure the internet moving forward. And we have a choice between a future of robust and open communications and a closed society filled with locks and restrictions, where the basic tools of expression that are necessary for expression are being used for political ends. Now, the internet has become one of the most vibrant platforms for human expression the world has ever seen. User-generated content has democratized media, allowing anybody who has access to a computer and an internet connection to publish their views to the world, instead of having it being restricted to only large media companies that had the resources to put out their viewpoints. This allows people with diverse viewpoints to find like-minded communities, so even if they are a minority in the particular geographic area that they're in, they can find people throughout the world that they can find solidarity with. And geographic boundaries have been reviewed by allowing for great cross-border flows of information. And internet intermediaries are a special concern because they are essential for the ability to seek, receive, and impart information. They facilitate communications. They can protect freedom of expression if they have policies that are appropriate for freedom of expression. And they provide avenues for democratic participation, which again is vital for a future that will respect human rights and human values. But just as intermediaries are vital for communications, they also provide points of failure. For an online communication to succeed, there usually need to be an access provider on both ends. There will need to be a service provider that is hosting the communication or the message. And there will need to be a domain name server that is helping to route that message, probably several other service providers along the path. And each one of them has a possibility of being compromised and a way of blocking that communications and interfering with the expression that's contained inside it. So while each is critical for this opening remarks, I wanted to focus on domain names because domain names are necessary instrumentalities of speech, and lately the integrity of the domain name system has come under attack. In June of 2010, the Immigration and Customs Enforcement of the U.S. Department of Homeland Security, or ICE, launched its Operation In Our Sights, which was seeking and executing warrants against domain names associated with websites that were allegedly offering unauthorized movie downloads. And then in November 2010 and February of this year, the government continued Operation In Our Sights, seizing a combined 92 additional domain names, again alleging that these were involved in copyright violations or linking to sports broadcast streaming. I'll take a moment here so seizure is kind of a misnomer. What ICE did was obtain judicial orders requiring service providers to lock domain names and direct traffic to a new address. In this case, a government web page announcing that those websites had been seized. So this is sort of like that right now, if you ask somebody, where is the United Nations headquarters, they would say 760 United Nations Plaza, New York City. But after this order, they would be required to give a different address, give false information about where that information is located, instead say 1600 Pennsylvania Avenue or some other location that would be set by the government. And so how can this process go wrong? Well, there are many ways, and there are a couple of examples that I wanted to use to illuminate the problem. One example was just sort of a misunderstanding of the system that caused a lot of collateral damage, and that was moo.com, M-O-O-O.com. And in February of this year, ICE seized the moo.com domain for allegedly pointing to illegal content, infringing content. But the thing is that this seizure temporarily blocked over 84,000 different sites. This was because that mu.com is a domain used by a service called FreeDNS that allows users to register a subdomain. So a subdomain would be like username.mu.com. And so they don't host any content directly on mu.com. They enclose it on these subdomains, and they include personal blogs, discussion forums, small business sites, sites where academic researchers are sharing papers and professional information, 84,000 different sites that were engaged in protected free expression activities. But due to allegations regarding one of those subdomains, I seized the top level, the mu.com domain, and all of the subdomains were taken down. And then another example, also coming out of the February seizures, which has profound implications for freedom of expression on the internet, is rojadirecta.com and .org, two domain names which I seized without prior notice. They were owned by a Spanish-based Puerto 80 projects, and they host forums which hundreds of thousands of users are discussing issues, posting information, highlights from various sporting events and other topics, and they included some links to streams of sporting events that could be found elsewhere on the internet as well. But what makes Roja Directa very, very interesting is that after a multiple-year legal battle, it had been determined by Spanish courts to be operating legally and not infringing copyrights. So that this was a site owned by a Spanish company operating in Spain that was determined to be lawful under Spanish law, but nevertheless was seized by ICE. And this sets a terrible precedent for freedom of expression. First of all, the seizure of the domain name is a prior restraint on the free expression that was done by the hundreds of thousands of users who are using this forum, who were having discussions who had nothing to do with copyright infringement. The seizure of the entire domain is not focused, it's not narrowly tailored to address the alleged harm, but instead is a broad swath that it took down everything with it. And also, and I think importantly, it fails to respect the judgment of the Spanish court and is imposing outside rules upon something which should be determined illegal in the Spanish court. Now, this is something which is an ongoing legal case in the United States. The decision to seize that domain has been appealed. The Electronic Frontier Foundation, last Friday, we filed an amicus brief in support of Puerto 80 and in their effort to regain control of the domain. So even as ICE is unilaterally taking on these domain name seizure powers, there also are some proposals to institutionalize this method of an attack on freedom of expression through the domain name system. A while back, there was a proposal called COICA, the Combating Online Infringement and Counterfeiting Act. And this was a proposal in the U.S. Congress, a flawed proposal that would allow the government to essentially break the internet one domain at a time, requiring domain registrars and registries, ISPs, DNS providers, and others to block internet users from reaching certain websites. And the initial incarnation, it was sort of particularly nefarious because it would have created blacklists. The first would be a list of the websites hit with a censorship order of a court, which is troubling, but at least it has some court involvement. The second blacklist, even more troubling, was a list of domain names that the government unilaterally determined without any judicial review were dedicated to infringing activities. So COICA was essentially a censorship bill that was running roughshod over freedom of expression. Now, fortunately, it failed to pass Congress, but that was not the end. And more recently, there was another proposal following along the same lines, the Protect IP Act, or PIPA. And PIPA is still riddled with problems for free expression on the internet. First, PIPA actually expands some of the abilities. It now includes a private right of action for intellectual property owners, which they can proceed directly against the domain name without any need for governmental action. So this is increasing the opportunities for this kind of blocking to occur. And has been expanded to include additional categories of third-party providers that could be subject to these court orders. And it requires targeted DNS server operators like ISPs to prevent identified domain names from resolving to the domain's IP address, and thereby preventing the users from accessing the entirety of those sites, sort of regardless of what information is on them. Now, there are many problems with that, and there's actually one that I wanted to highlight in particular, which is security. And if the government, the United States government, begins to use its control of the critical DNS infrastructure to police alleged copyright infringement, it's very likely that a large percentage of the internet will start to shift to alternative DNS systems. Like, this is not going to be a particularly effective tool in the long term because there are many ways to route around the DNS system. You can have a local host file, you can have a third party that provides DNS services. But these alternative DNS services will become targets for security attacks. It allows for competing DNS mechanisms, and this can make phishing easier. It can make attacks that redirect someone to the wrong website much more easy. And also, if you have a system where redirecting users to a resource does not match what they actually requested, this is incompatible with end-to-end implementations of DNS security. And DNS security is something which is really vital to the continued function of the internet. So to conclude, I would like to draw from the view expressed by a coalition of engineers who wrote an open letter. These were engineers who were active participants in the construction of the internet. And they wrote, "We can't have a free and open internet without a global domain name system that sits above the political concerns and objectives of any one government or industry." So thank you. And with that, I think it's time to turn to discussion. And perhaps as a starting point for discussion, I want to take a lead from what Pedro was suggesting, and perhaps we can start discussing with this recent proposal from China, Russia, and Tajikistan, Uzbekistan on an international code of conduct for information security. And I wanted to highlight one aspect of that which seemed interesting in the context of freedom of expression on the internet. And that was that provision 3, allowing for the curbing dissemination of information which incites terrorism, secessionism, extremism, or undermines other countries' political, economic, and social stability or their spiritual or cultural environment. And so the question I have is that overly broad? And would that allow a country to engage in censorship? Sir.
Thank you very much. I'm Eduardo Bertoni from the Center for Studies on Freedom of Expression and Access to Information in Palermo University, Argentina. And the answer is yes. It's against any human rights standards. And I also want to highlight another, I mean, Pedro said that one of the problems of this proposal of resolution for the General Assembly is that the wording is very vague. But this is problematic since the number 1, because it introduced this idea to respect for the sovereignty, territorial integrity, and political independence of all states. And I have been, doing some research on defamation in the internet and jurisdictional problems. And this idea of sovereignty, I read yesterday a paper that was distributed here that somebody says, I think that was you, that this idea that the internet is destroying the sovereignty idea came from the Westphalia notion. And I think so. And introduce this idea of sovereignty in a resolution of the UN is really raise a lot of concerns. And in the same way that we need to applaud when international governmental organizations like the UN make good statements, like Frank LaRue's statement, like the joint statement, we need to be aware of these kind of setbacks. And one brief comment that is not related to that, if I may. When we are talking about protection of human rights, we know that we have the universal system for protection of human rights, but we also have regional systems. In the panel is a representative for one regional system, which is the regional system from Europe, but we have more. We have the Inter-American system for the protection of human rights. We have standards, and we have standards that in some way are stronger than the European standards. If we, the Latin American countries, are complying with the Inter-American Court of Human Rights, it's part of other discussion. I think that there is a lot of compliance. But what I want to say that one of the standards that we have that make a lot of difference between the Inter-American system and the European system is the prohibition of prior censorship. This is something that Article 10 of the European Convention on Human Rights doesn't have, and this is something that Article 19 of the ICCPR doesn't have. And the Inter-American Court of Human Rights in an old decision said that prior censorship is prohibited in the Inter-American system. Why I'm stressing this point? Because we were discussing with Johanna Carlos Afonso in the workshop that we organized in Buenos Aires a couple of weeks ago when they presented their paper, this idea of filtering as a way of to be a prior censorship. If filtering is the same, and I think so, of prior censorship, in the countries that are binding by the Inter-American Convention on Human Rights cannot pass laws that filter because of the prohibition of the prior censorship. So it is complicated. The prohibition is a very high standard. It's only one possibility related to child moral and something like that, Article 13.4. But this is a problem that we, I mean, in some way we have a solution in the Inter-American system, but it has some more problems because now we need to harmonize this regional problem with the regional system with the other international system. Thank you.
Thank you. And would you like to respond since you were named specifically?
Well, actually, it's one of the elements that I wanted to highlight. I'm Bertrand Lachapelle. I'm the International Diplomatic Academy, and I do not speak here on behalf of the ICANN board, of which I'm a member. On that point about sovereignty, a clarification of what I said in the paper. What the Internet does is not to suppress sovereignty, is to challenge the notion of sovereignty based exclusively on physical territorial borders. Sovereignty is an extremely important element. It's just like in contracts, and I want to say that on the record. You cannot contract if you're not free. If you're not sovereign, you cannot participate in an international environment. So sovereignty is good. Can be even extended to individuals, but that's another issue. However, with the Internet, sovereignty gets and brings responsibility, because what you do at the national level has an impact on the international level. And one of the things that the Council of Europe has allowed to explore in the working group that was set up, and of which I'm proud to be a member of, is the notion of responsibility for states regarding the actions they have on other countries. And the analogy that is underlying this is something that goes close to what happens to waterways, and the fact that when you are, for instance, in the line of a waterway, the upstream has a responsibility for the downstream. If you take an action at the national level that has an impact on another country, this is actually infringing the sovereignty of the other country, which leads to the second point regarding the ROJA Directive. It is extremely preoccupying to see that in the case of ROJA Directive, the Spanish sovereignty is actually being infringed upon. And all governments in the world who are fighting for their sovereignty should be caring very much about misuse of the domain name system to extend the sovereignty of one specific country to another region. This example is one, but there are other examples like tampering with the routing system of any sort that actually has an impact on the citizens of other countries. So this notion that we are seeing today, not a battle, but a question about what is the definition of the boundaries of jurisdiction. And this is an ongoing battle, and obviously in the case of ROJA Directa, it's going a little bit too far, and those cases are very useful, and it doesn't even have to do anything with the content. I don't care in that case about the content. I'm talking only at the level of how do you define jurisdiction. If the mere fact of having bought a domain name from a registrar in a country is sufficient to extend the jurisdiction, this is problematic.
Thank you. Would you like to, please?
Just a point of clarification. Yes, the European Convention on Human Rights doesn't, Article 10 doesn't have an explicit expression saying no prior state control on content, but it has a number of conditions that should be met for any kind of interference with freedom of expression, and those are prescription by law. An interference has to be prescribed by law, it has to be necessary in a democratic society, and it has to be proportional. And the European Court of Human Rights goes through a very strict test to see whether those conditions are met. the no prior state control language is actually introduced in other standards of the Council of Europe, and I was mentioning a declaration on freedom of communication on the internet, and there it is explicitly said no prior state control. Another point I'd like to take is the domain names. Last week, the Committee of Ministers of the Council of Europe adopted a declaration on domain names and freedom of expression, and there it said explicitly that the standards, the international human rights standards, apply to domain names. Freedom of expression should be guaranteed in connection with domain names, and that there should be a strong presumption in favor of expressions included in domain names.
Thank you. Ben, you had a question?
Yes, just a short comment, because my name is Ben Wagner. I'm from European University Institute and coordinate the Dynamic Coalition on Freedom of Expression here at the IGF. From what I've seen so far and from what I've noted of this panel, I'm actually slightly concerned. And the reason is that I've just come around the corner from another panel, which is talking about finding ways of norms of blocking and dealing with domains and regulating content. And they were quite openly and relatively explicitly talking about measures in which DNS can be improved to ensure that illegal and questionable content can be removed from the internet. Now, I hate to say it, but many of the great statements that have been made here sound slightly like preaching to the choir. And with all due respect, the people that were in that room were all, or to a great extent, local people who were discussing considerable real problems that they had with issues that were related to content that they didn't like and they wanted to be dealt with. So I think it's important to remember that when we're discussing freedom of expression and the different articles that can help it, the different paragraphs, the different frameworks that can improve it, that might not be sufficient to convince everybody, and that we might also need to passionately argue for what we really care about and what really matters in this debate, which is a deep belief in the value that freedom of expression will improve the societies we live in, rather than simply suggesting that Article 10 might be useful in certain circumstances. And it's this passion that might also help convince the people in room 13 around the corner that content blocking might be a useful tool in certain circumstances, but might have massive negative implications for their societies. Please keep that in mind, and also perhaps consider intermingling with this group afterwards. I'm sure there are lots of wonderful people in this room who would have very interesting things to say to them. Thank you.
Thank you for that remark, and maybe it's not too late. We can get some volunteers to go there and invite half of the room to come here and exchange a little bit of opinions. If somebody wants to do that, will be more than welcome.
Hello, my name is Wael Khalil. I come from Egypt. I'm an IT professional, but I'm here as an activist. A problem I'm having with what I'm hearing in this session and in previous sessions regarding privacy and freedom of expression is that it works on bilateral relationship between governments and corporations. And sometimes courts are invited or not, and courts not universal courts, but courts in European, if I'm a European citizen. And I'm failing to find ways for individuals, activists or citizens to support either way. How can we as individuals support more freedom of expression against corporations who have more interest in their government relations, whether they're Google's, whether they're Facebook or Microsoft, and without access to courts? We don't in Egypt have access to courts. Should we start thinking about sanctions against corporates and governments? I mean, I don't think we can give up on using Google or Microsoft or Facebook, but I think they're going to, I love them, but I love Google and everything, but I need to have a way to influence my position when Google removes a YouTube video that shows torture in police stations in Egypt, because it got complaints from the government, from a clever lawyer that works for the government. Then I have to have a way to retaliate, to actually have Google. The same goes for Facebook, shutting down pages at will, because we don't have any clarity or transparency of how they make these decisions and how we can confront this decision. And I like more of the discussion towards how citizens, how individuals can influence the debate that actually it's really between governments with their interests. So the government of the United States would support or encourage Twitter to be available in Iran because it has problems, but when it's shut down in Egypt, it's really not very much keen to react because the Mubarak regime was an ally regime, and we have to have a way to counter that and influence that more than simply file a court case that we cannot afford. Thank you.
I know there are many people, but I would like to address one of his concerns in terms of what happened when an intermediary that is right in the middle of the situation. For us, obviously, our primary responsibility is to our users. Our users as first, and is much more important access to information and freedom of expression than government relations. And I'm the head of government relations for Latin America, so I know how hard is that. In terms of dealing with this kind of request, what we come up is, there is no one only solution for each of the problems because we need to assess different issues. We need to assess cultural implications. We need to assess local implication of if we are present in a country or not, political implication of that moment. And what we do is be totally transparent. We show every request that we receive from the government. And also we have terms and conditions of what is the content that we are accepting and which is not. For example, in case of torture, we face different cases, like we are not allowing content that is distressing, for example, in YouTube, and that could be shocking. But sometimes there are content that is shocking, but it reflects a reality that is a torture. And this happened with a case, I can't remember in which country it was, but at the beginning it was taken down because it was evidently something that was shocking, but then when we got the reply from the poster, then we put it up again because it has a value for society. And we have been suffering for this. And we have different scenarios here. For example, if I not recall, I think that was in Malaysia, we have to comply with local law that says that the citizens cannot say anything against the king, for example. And this is a local law. And in Turkey, when there were videos that were against Atatürk, for example, the father of the nation, the Turkish government asked YouTube to remove this content from the whole YouTube and not just for the access from Turkey. And we draw a line there and say, no way. That we cannot take this action because it affects the whole world and it's not proportional. Even if under local law that might be illegal. So those are, the challenges that we face, and for that it's really, really important to have a very strong framework on a safe harbor for internet intermediaries. This is also that would help the different countries to have local developments, because otherwise you only will have companies maybe with a base in another country that has the possibility to deliver this kind of services in your country, but you need to have local ones. And local development, it's when you have to analyze, okay, well, I would like to start a new platform on that user could exchange content freely. You need to do an analysis of which is your legal exposure. So if you don't have those safe harbors, you don't have this limitation on liability of internet intermediaries, you will see that there is a lot of risk to engage in this activity. So that's, sorry to take too much time on this.
Thank you. We have a number of people who would like to talk, but I wanted to invite the special rapporteur, Frank LaRue, to say any comments that he may have.
I'll say it from here. Two things. I refuse to think that...
Come to a microphone so we can get onto the record, please.
I refuse to think that there is a unbridgeable difference between what states wants to do and the protection of human rights. I think both are perfectly feasible. I said in the report as well that some concerns of the states are absolutely legitimate. Terrorism is a reality, for instance, in the world. One cannot deny that. And anti-terrorist activity is a legitimate activity. The same way that combating organized crime or drug lords is a legitimate activity. The only problem is that to act within the communications world against terrorism or against organized crime or child pornography, which for me is part of organized crime affecting children's rights, means that it has to be defined by law. The principles that were being stated by the friend from the EU is not that the states cannot act in blocking a website, is that there has to be a very specific procedure. And in an open society, these procedures have to be seen as the exception and not the rule. The problem I find is the state find the temptation, whether it be on intellectual property rights, whether it be on protection of children, whether it be on the cultural values, whether an image is too offensive and too violent. But this is the right to know, the right to truth that victims have of knowing what happened. WikiLeaks, for instance, was seen differently from Washington than it was in the rest of the world. Or every other issue that concerns any particular, we can't decide freedom of expression on the basis of individual concerns of governments or even on the interpretation of international corporations. There has to be common standards. And that's the principle I'm thinking. They have to be established. Limitations have to be strong, have to be concrete, but they have to be established by law. They have to be clearly defined, unambiguous. They have to be necessary to uphold other human rights and very clearly defined, and they have to be proportional. And that, I think, solves, in a way, the problem. I believe that this even avoids the prior censorship. I mean, probably all governments are doing monitoring by now, whether we know it or not, but it's not the same thing to allow governments to do the filtering or to actually have governments transfer the responsibility to the ISPs, which that should not happen either, unless, on an administrative political decision, unless there is a court order or of some authority based by law.
Thank you. I believe we have a remote participant, Paul.
Yes, we do have a question from a remote participant. His name is Yuri Anikiv from the Moscow State University, Russia, remote hub. His question is to any member of the panelists. He wants to know, how do you see the role of professional journalists in the process of expanding and maintaining free flow of information on the internet? Thank you.
Well, this is Kurt from the Electronic Frontier Foundation. I think that journalists, whether they are professional or amateur journalists, are vital to the free flow of information. That by interpreting information, by collating it, coalescing it into a understandable form, and then presenting it, journalism is vital for people's understanding of the world. Now, the question involved professional journalism, and I think that in this modern era of democratized media, there are actually a lot of people who are amateur journalists and yet are still providing important flows of information. So I wouldn't make as much of a differentiation between them, though there is great value in having the resources of an investigative journalist. So there still is a very important role for media to be able to bring some resources to bear and to do a greater investigation. Jeremy?
Thank you. I'm Jeremy Zimmerman, co-founder of Paris-based advocacy group La Quadrature du Net. I won't troll much about policy because most have been said before, but I want to introduce some notions in that debate. We have a perspective here with ACTA and measures to deter further infringement that are being pushed upon intermediaries that are also part of the G8 conclusions and the OECD and Michel Barnier's EU Commissioner for Market Commissioner in his IPR guidelines and so on. So under the pressure of, for instance, criminal sanction, like in ones of ACTA, we see intermediaries being turned more and more into a private copyright police. And I like to hear Google explaining about, you know, the user first and so on. But Google was one of the first companies to implement those voluntary measures with YouTube. And to allow rights holders to get access to a special interface where they would define what kind of content, images, sounds, etc., would be automatically removed, automatically censored. It's on YouTube that thousands of parodies of the downfall, der Untergang, this wonderful movie where it was extremely intense scene that was used for parodical purpose. Hundreds of videos at once were removed on one complaint of the studios. So the notion I want to add here is, given this threat on the global fabric of the internet, this threat on the very nature, the very architecture of the internet, can we dissociate any longer the question of freedom of expression from the question of owning the infrastructure, citizen-based owning of the infrastructure, which means using free software, hosting your own decentralized services, providing your own network access, whether wireless using mesh technology or doing your own ISP with a bunch of friends? Are those questions decorrelated anymore? And I'm a bit concerned when I hear activists saying, yeah, I love Google, I love Microsoft, or when I see the number of activists using Apple software or Google for hosting their email. I think those questions are deeply linked and that we have to address them together.
Thank you. And you had a question.
Ian Schuler, excuse me, Ian Schuler. I work on internet freedom programs in the State Department. I think I'd like to thank the panelists. I think it was a great overview of some of the threats to freedom of expression, particularly in places that are democracies that generally enjoy some degree of rule of law. But in countries that don't enjoy those sorts of rule of law and democracy, there are additional threats to freedom of expression. I think if you look around at a number of oppressive countries, it's not, in addition to filtering and blocking some other things you're also seeing governments take offline actions, tracking what people are doing offline, harassing them offline, tracking what they're doing online, and harassing them offline as well. And you see SIM card registration requirements, you see tracking of content, man-in-the-middle attacks on popular services. And I wonder if, and certainly this has a chilling effect on people's ability to actually realize their rights to freedom of expression. So I wonder if any of you have looked at some of the proposals that are being made to further erode anonymity online and to change the infrastructure in a way that would make it easier for governments to track and identify content that's posted to real human beings, and what effect that has had on freedom of expression in places such as Syria and others, where it's notable that when the Arab Spring revolutions began, that they stopped blocking, they turned back on Facebook and Twitter in order to be able to capture that sort of information.
All right. Well, then I will respond briefly to that. So absolutely, anonymity and being able to protect your privacy is fundamental to freedom of expression. That a viewpoint that is unpopular in the home region of the speaker places that speaker at risk at the hands of an intolerant government. And being able to communicate anonymously is something without which you can't have true freedom of expression. One of the ways that EFF has encouraged people to help protect themselves is through Tor, the Tor project, which is a technical method to help people communicate anonymously without having it easily tracked back to where they are. And we're also very much opposed to legalistic requirements that require people to do registration before they go online. And finally, you also mentioned things like Facebook, and this is one of the reasons why we like to ask all the social networks to not require true names. Both Facebook and Google Plus have a requirement that people use their real names online, and this has some issues for activists.
Thank you. Vicky Nash from the Oxford Internet Institute. I think, for me, this is a really fascinating panel, largely because at last we're having a wider debate about how freedom of expression is impinged upon by a much broader range of sort of policy areas, perhaps, than we've been used to discussing before. I think often there's a tendency to focus specifically on, censorship of political speech or the issue of child abuse. You've talked a little bit about intellectual property and copyright as an area where policy is increasingly infringing on freedom of expression rights. I wonder whether you had any thoughts about any other particular policy areas where you thought that sort of movement was worrisome in this area. Thank you.
In that regard, I think that privacy, it's also another area. We see increasing privacy regulation around the world that focus on that could target speech, because somebody that published something about someone could be treated as an infringement of privacy. So that is another focus that has a clashing against free expression, and sometimes questions related to competition. It's another issue. For example, ChileanEffects.org has studies about how sometimes the requests of the DMCA are aimed to hamper competition, for example. So we saw that a lot, and I think that those are other areas that we need to keep an eye on. Particularly in Latam, we're seeing a lot of developments on the privacy front. Just in order to give the gentleman on the Quadratura.net some explanation on the YouTube and the downfall, well, there is a blog posting from us on YouTube explaining why this happened, and in fact, the users always has the option to counterclaim any claim that is performed by a copyright holder. We try to get the best solution possible for all. The amount of information that is uploaded to YouTube, it's unbelievable. Like every minute we have more than 40 hours of video on YouTube uploaded. So this is something that is impossible to keep track without any kind of tools that will help different stakeholders to exercise the right. So Content ID, which is a technology that allows you to do that, doesn't analyze the purpose of any parody of any publication. So it's up to the user that uploaded, that when he receives a request to take of a copyright holder to take down that content, to also counterclaim that. And when the user do that, the content is up again. So, and this is because we are a company that is incorporated in the United States, and we have a set of regulation that basically is the Digital Millennium Copyright Act that says that we have to do that in order to not be liable for user-generated content. This is what happened. In other countries, what we are fostering, and it's a good example of what happened in Chile, for example. It was a revision of the copyright law, and it says that any takedown should be ordered by a court order. So it's no private notice and takedown system. So it's a judge who in charge of deciding if a given content is infringing on copyright. And it's up to the judge also to weigh not only the copyright infringement, but also the impact in other rights like free expression or access to information. So those are also very interesting models to start to analyze and maybe expand to other countries. Thank you.
Thank you. My name is Anja Kovac. I work with the Internet Democracy Project in India, and I'm also a fellow at the Center for Internet and Society in India. I just wanted to respond in part to Ben's point about the importance of strengthening cultures of freedom of expression. I think this is something that we are very strongly experiencing in India. Traditionally, there are ways in which even civil society has dealt with the enormous diversity of that country and the very big differences, disagreements that exist, which in many other countries would come as a surprise because they do include sometimes censorship. And that means that there is a broader culture that accepts censorship in certain cases which perhaps would not be acceptable, especially in many Western countries. And I do think that many of the strategies, even progressive civil society has had to deal with these kind of conflicts, are kind of blown up by the internet. If we want to keep that open, empowering potential of the internet in life, we have to deal with these issues. And I think we are also trying to work on that and trying to change this culture, which is a very long-term thing, obviously, a very difficult challenge, but I think both civil society and government is taking that up. But it would be nice to get some help. And unfortunately, I must say, I think intermediaries there have played a very worrisome role in the sense that I think they are often a little bit too proactive. For example, if you take the example, if you search for the word sex on 3 different search engines in India, what you get on Bing is only a little message that says, because of the safe search settings of your country, this content is not available, something like that. There is nothing. If you look on Yahoo, you get a mix of search results, but the majority are, they've kind of filtered out most of the porn, etc. So there is more of an emphasis on the educational aspects. With Google, it's much more of a mix. But I think it's really problematic, even if you talk about business models, a certain insecurity in terms of the law, Bing clearly did not have to go that far. The Center for Internet and Society will also be releasing, it's not released yet, but a research study in which a person has sent takedown requests to 7 major intermediaries. 5 of them took down immediately without even asking any questions. So if we are to change those cultures and really strengthen in general the atmosphere of freedom of expression in general in our countries, I think we need some help from intermediaries. So I'd be very grateful if maybe some people on the panel could also respond with suggestions on how, perhaps in consultation, we can strengthen these things. Thank you.
Would like to respond, or we'll take another question in the back. I'm sorry, we're running low on time.
Hi, I do hope my question is not actually very stupid. My name is Frida Mori-Bruce. I'm from the Nigerian Communications Commission, the telecoms regulator in Nigeria. Except I like to believe we are all global people. We are always on top of global news, and if we are, then I expect everybody in this room should know about the situation Nigeria is going through today with Boko Haram. I mean, we're here at the UN, and as you know, the Boko Haram was the one that bombed the UN in Nigeria, where about 30 people lost their lives. The telecoms regulator has had a lot of problems because of the situation in Nigeria today. For example, there was a time that there was something published by a Belgian person about Mohammed. And we immediately got information from the SSS, the National Security, immediately telling the regulator to get all the ISPs to get the information out. Because in a country as volatile with religious situations, the moment you do anything against Mohammed, then of course you know you're going to have a lot of deaths. And as a result, the regulator was forced to do that. When you talk of freedom of expression, like I said, I hope my question is not going to be stupid. But when we talk of freedom of expression, my question is, whose freedom? Whose freedom? Is it the freedom of a few or the freedom of the larger body? Today we have a situation where with Boko Haram, for example, our independence comes up on the 1st of October. And they have put up a lot of threats. They have threatened to bomb so many places. Before it was in Abuja, the capital city. Now it's gone down to Lagos and places. And I was in Lagos a few days ago, and everybody was afraid. You had army and everything. Now, these people are nameless and they are faceless. Right now, they are using newspapers. We don't know how the articles are coming out, but they are using all these kinds of mediums. It is very clear that they are going to soon start using the internet. So if they put up something on the internet threatening the whole nation, what is the government to do? Are we actually meant to take that down, or are we meant to leave it? There's a good possibility that they won't do it on the national space. They might go onto Twitter. Are there any international instruments that Nigeria can actually get that thing taken off of Twitter, which is an international domain space which does not belong to us, because that is a threat? Another thing is that today the media in Nigeria really are not talking about Boko Haram. It is too sensitive. Nobody really talks about, because if you speak about them, they kill you the next day. They told the governor to apologize to them, and he didn't, and he was killed. And because they are faceless. So is there any way also for the media, who obviously are the ones who are bringing out the issues, to have a level of freedom of expression, or where their IP addresses can be so secure that these people can't actually find them? Because as a country, it's easy to say, you know, let's put in the regulation, have a process. Sometimes you're being forced to do fire brigade approach. And as the regulator for telecommunications, we are finding out that the government is putting the emphasis and the onus on us to try and, you know, mitigate the risks of these people. So I wondered, if we start to, if they put up things in international space, is there any instrument that the government can do to actually try and block? And is there any way to block IP addresses so they can't see and actually go against and kill innocent people who want to speak up against them? I hope it's not a stupid question, but I don't have the answer. Thank you.
So
we're almost out of time. I mean, I thank you for the question, and this is one of the great tensions that comes up. We have a remote participant. Let's go to that now.
Okay, so we have Philip from the remote hub in Austria. He wants to ask his question.
1 second. Philip, can you hear me? May I ask you please a question? Can you please mute your speaker so that we don't have a loop back?
Thank you. Oh, there we go. That's much better. We've had a number of questions that have come from the last 3 or 4 speakers that have been addressed to the panel. We are almost out of time, so I thought what we should do is just give my co-panelists here an opportunity to give some concluding remarks, and if you can address some of those questions. Let me just begin by addressing a couple of the points that just came up. One is the question about whether the UN is the appropriate body. And I think that one of the things that's very important is to have a multi-stakeholder body. And one of the things that I appreciate about the IGF is that it brings together a lot of different stakeholders. So the UN may be the convening authority, but it is critical to have civil society participants and corporate participants, and make sure the views of the users and the citizens are represented as well. On the tension between situations where there is incitements to violence and crimes online. One of the most important things is to have due process, and one of the great tensions that we have is that infrastructures that are designed to block content can often be used and are being envisioned in a manner that does not have due process, so that it can be misused, and so it can be used to over-squelch speech. So you might have, we were talking about a little earlier, blocking a domain name, so it may be that there are 84,000 sites on Moo, and one of them is one which is actually problematic, as is making a threat or is do something criminal. But then you have 83,999 that will get swept up in the same process. And so, in order to protect freedom of expression on the internet, we have to make sure that there is good process and that there are narrowly tailored, so we do not overly restrict freedom of expression. So, with that, I will turn it over to my co-panelists for any concluding remarks.
Yeah, thank you. My concluding remark is what the Council of Europe has stated in many of its standards. Human rights and fundamental freedoms apply equally and without distinction online and offline. There is no such distinction as human rights apply this way online and another way offline. They apply equally. This principle should be, in our view, a reference for all stakeholders, for states, for the private sector, and for civil society as well. And as regards freedom of expression in particular, and its protection, this is not a one-time effort. It requires continuous efforts by all stakeholders, and keeping an eye on developments, and as we've seen in this very interesting discussion, the threats to freedom of expression emerge as by the day, and as the technology evolves, and as more people will come online. So it is a continuous effort to protect freedom of expression and access to information online. Thank you.
I'll just briefly add to that. I think we had a very rich discussion, and I've taken a lot from all the comments that people have made about doing further research, and also in how, you know, using technology, and especially cryptography, you know, and other technologies could help to somehow maintain some aspect of freedom of expression at the moment, whilst we do not have an ideal system. And lastly, we do know that genie is out of a bottle, and trying to stop people to freely communicate is really like stopping people to print after the Gutenberg print has been invented. So I want to end on a positive note, that we really need to be vigilant of all the surveillance systems that governments, oppressive regimes may be able to build, and we need to be vigilant of the other uses that also corporations may build, being coerced or nudged by certain systems to do so. But no person or organization should be deprived of their ability to connect to others, and without the due process of law, and in developed countries this due process of law works much better than in other regimes, and with the presumption of innocence until found guilty. And I will pass that on to another.
Well, just as, you know, a closing remark, and also addressing some of the concerns about the relationship with companies and human rights activists. I think that internet is not only an enabler of human rights, but also is an enabler of the dialogue around human rights. So we need to use this tool in order, and also to have a greater discussion around this, and also try to foster more companies in order to get a code of conduct in terms of how to deal with freedom of expression and human rights. A good example is what happened with the Global Network Initiative, and we are, you know, we are members of this initiative, and we would like to see more companies joining this kind of code of conduct in order to be totally respectful of human rights and free expression online. In terms of some of the concerns about this balance between illegal behaviors, online threats, crimes, I would like to draw a line here and differentiate that the medium doesn't change the crime. We are facing terrorists, we are facing criminals that are using different mediums. That doesn't mean that because they are using the internet, they that's not to be punished or investigated. I think that it's just another medium to do this. And I don't think that it's logical to say, okay, this is an issue of internet, because I remember that this kind of discussion happens when the books appear, and somebody was using printing press to express some ideas that somebody really don't like. So it's not a question of a medium, it's a question of cooperation, international cooperation in terms of crimes, in terms of terrorism, but has nothing to do with internet. And I think that sometimes we see that the discussion on terrorism turns into cyber terrorism, and it's not like that, it's terrorism, it doesn't matter the medium. In terms of intermediaries, I think that, and has to do with the question that we received from the Austria hub, intermediaries needs clear rules on how to proceed to deal with illegal content. This is very important, because intermediaries don't want to get caught in the middle and become judges or executors of our users. This is, even from a business point of view, it's crazy that you block and sanction your user. It's not the position that the intermediary wants to have. So this is very important. If we have clear rules, and also, you know, it is a big difference between a big company that has the resources to hire lawyers to defend herself than a small ISP or a small online platform that really don't have the resources and got scared very easily because they are not able to exercise their right, and has to do a lot with also access to justice in the different jurisdictions. So if we can work on this, if we can work on also global standard on intermediary liability, this will be very, very important to guarantee free expression online. Thank you.
Hi, I would like to say that it was a very interesting panel. I'm very glad with the inputs. And for last remarks, just to say that now, especially in Latin America, we are in an important and very challenging process of crafting these laws, and it's crucial to be close to all the stakeholders, either companies and governments. I would like to highlight one, trying to address Anya's questions on companies. I'd like to highlight one initiative from our colleagues on Access Now, which is a seminary on human rights at the Silicon Valley. So I think the goal is actually that, to approach all the companies and make they be aware of the fact that they are dealing with human rights issues now. And I think that's it.
All right, well, thank you to all of my co-panelists. Thank you for all you participants remotely and those who are here for having a great panel. And we'll be around, I guess, I will be available after if anyone wants to talk outside the panel, but otherwise, thank you very much.